Welcome back to Winning Isn't Easy. Now, as a physical therapist, you have patients who have been involved in motor vehicle accidents, and they're dealing with a claim against the insurance company. You probably have workers' compensation clients who have been sent to you by the workers' comp carrier, and you're dealing with forms. And you may have patients who are claiming Social Security disability benefits. And again, there's lots of forms, not necessarily forms that you're involved in, but there's also disability insurance claims. And so you might have some clients who are actually on shorter long-term disability benefits. And I'm positive you've heard all sorts of complaints from all four of those groups about the claims process. Now, the claims process is unique. What you have to prove in a motor vehicle claim is different than what you have to prove in a workers' comp claim, which is different than what you have to prove in a Social Security disability claim, which is different than what you have to prove in an ERISA disability or IDI disability claim. So let's put aside your notions or understanding of those types of disability claims. Clean slate. Now, you may have gotten your disability insurance policy one of several ways. You might work, for example, a hospital, and that hospital has offered you as a benefit short and long-term disability benefits. If that particular hospital is church affiliated, it may not be what's called an ERISA disability plan, but the concepts are the same. Now, you also might be eligible, as many of my clients are, to have a policy through a physical therapy professional association. That is probably not an ERISA disability plan. And if you have bought your own disability policy through an agent, that's called an individual disability policy. That is generally governed by state law as opposed to the ERISA federal law that will govern employee-provided benefits and professional association benefits. So the two carve-outs are going to be, hey, ERISA disability, most likely an employer-provided plan or policy, so long as it's not a church plan. And over here, you have a policy offered by a professional association, probably an ERISA policy. On the other hand, you've got a policy that is being offered to you by your employer, but they're a church-based, probably not ERISA. And certainly, if you've gone out and bought your own IDI policy, not governed by ERISA. Those two would be governed by state law. But regardless of what law is applicable, and that is important to know, the first step in this whole process is getting your disability insurance policy or plan. You have to really understand the terms and conditions of your coverage because there is no uniform disability policy or plan. Many disability policies or companies like Unum have multiple versions of the same policy or plan. This isn't like a workers' comp statute where the statute is the statute and there's some case law that interprets it. Every policy or plan is different. So we want to start out by getting it, and we want to read it cover to cover. One of the things that we want to understand from the very beginning is there what's called an elimination period? You have to wait a certain period of time before you can actually collect your benefits. Some policies or plans will have like a 90-day waiting period where you're on your own for the first 90 days. Another important element is the definition of disability. Now, why is that important? Some policies or plans will define disability as the inability to perform your own occupation, which means that if you're unable to do your job duties as a physical therapist due to injury or illness, you qualify for the benefits. But there are other definitions. The inability to do the material and substantial duties of your occupation can also be a definition. So sometimes carriers might say, well, charting is an important duty and you can do that so you're not disabled. So again, it really is important that you understand what that definition of disability is and definition of occupation. Now, what will often happen is that after 2 years, the policy terms will change from an inability to do your own occupation to an inability to do any occupation. And That period of time, that 2 years, can differ from carrier to carrier. It could be 1 year, could be 2 years, could be 5 years. But what happens is that the definition of disability changes from an inability to do your own occupation to an inability to do any occupation. And that means that if you're able to do any other type of work, particularly of a sedentary nature, you may not qualify to receive your benefits. Now, again, occupation is important because that definition can be based on how you're performing it, how it's performed for your employer, how it's performed in the national economy, how it's performed consistent with the Dictionary of Occupational Titles. 4 different tests to how occupation is defined. But you don't know that until you read the policy or the plan. Now, hopefully you have a policy or plan that provides what's called residual disability benefits. If you can't work full-time, but you can work part-time, you might be eligible for residual disability benefits. And that's particularly true with some of my self-employed physical therapy folks who have residual disability benefits in their plan. I know that there are not a lot of self-employed physical therapists left these days, but regardless, if you have a policy or plan that provides residual disability benefits, potentially you can work and collect benefits. You are going to have to submit tax returns, pay stubs, records of that lost income, including your billing records. The billing records obviously will be confidential, but you might be able to get part-time benefits while you're working in a reduced capacity. Now, the other thing you need to understand is before you stop work and apply for benefits is that there are policy terms that can impact how much you get. You might be eligible for Social Security disability benefits, and your carrier is going to say you have to apply for these benefits. And if you don't, we're going to act as if you're getting those benefits for you and your minor children, and we're going to reduce your disability benefits by the receipt of that Social Security. Similarly, if your disability is caused by a workers' comp condition like repetitive trauma or an acute accident or injury, many disability policies or plans will reduce the payment of benefits by what you get for lost wages for your workers' comp claim. And again, each policy or plan is unique, and some are broader than that. If you were involved in a motor vehicle accident, you can expect that there is a other income offset provision in there that says if you collect or get benefits, we get the right to reduce your long-term disability benefits by whatever you get. Now, that, again, is a unique term in every policy or plan. Some will say, hey, if the settlement that you get or the money you get is for lost wages, that's all we're going to reduce your long-term disability benefits by. Others are broad. If you get a settlement that includes compensation for past medical or future medical, the carrier or plan may say, we still have the right to an offset. Again, it comes back to the terms of the policy or the plan. So you can see that you need to understand the terms of the policy or the plan. Picking the right date to apply for benefits is also crucial. And what's in your medical records is really crucial, because if you pick a date that's not supported by your medical records or your doctor doesn't support your claim, that can be a non-starter right out of the gate. You, in the course of your profession, take an interval history. You ask the patient, well, how are you doing? Did you get any benefit from it? And they'll tell you all sorts of things the carrier would love to know, and which they can use to ultimately deny or terminate benefits. It's really crucial that you're giving a very good interval history of your symptoms and functionality. Symptoms, functionality. So you should know that. Because ultimately what the carrier is looking for, the plan is looking for, is consistency between what it is you say you can't do, what you're reporting to the doctor, what you may be doing on social media, and please turn it all off, and what your doctor has to say. Because many times disability carriers or plans will say, this is inconsistent, or you're taking too long to recover, and we think you should have recovered by now. What you're doing is inconsistent with the level of pain or the level of the restrictions and limitations that the doctor has assigned. So again, you know this as a medical professional, it's documentation, it's consistency. You can see that having an attorney help you apply for benefits and manage this claim can be really crucial, because there are some mistakes that you can make that cannot be fixed after the fact. The attorney can make sure that the claim is properly documented and filed, assist with required medical and financial records, and you can probably anticipate your statement will be taken. You may have had your deposition taken. It is like a deposition, but you're on the hot seat, and what you have to say can impact whether you get your benefits and how long you get your benefits. So you want to have an attorney who will help you prepare for that statement. Obviously, at the end of the day, you need an advocate on your behalf in the event that your claim is denied or ultimately your benefits are terminated. Got it? Well, I hope that you have found this episode helpful and insightful as to the nature of the disabilities that we see in the ERISA world involving physical therapists, how to go about filing a claim, learning what your policy or plan has to say, and creating a strategy to submit not only a winning application, but to stay on claim. So you can see that this is complex, but you're used to complex things. You may be tempted to try to do it yourself because, after all, you're a physical therapist and a medical professional, but you don't understand insurance law, ERISA law, the kinds of proof that is required, the consistency that's required, and how to manage your own claim. Yeah, I know you've talked to insurance companies about the benefits and dealt with claims, but this is a different animal. So please don't try to do it by yourself. If you found this episode helpful, please take a moment to like our page, leave a review, and share it with your family and friends. And of course, subscribe to this podcast. If you have any questions about your rights to your ERISA or IDI disability benefits, please feel free to give us a call at 727-894-3188. We do handle claims across the United States, and we're familiar with every disability carrier plan in the United States. So, got it? Hope you found this helpful. And please, we hope that you subscribe to this podcast, and we look forward to having any questions that you have presented to us so that we can help you navigate this process. Thanks.